get myself on stage. There we go. We're going to get started with the show. Happy Sunday, everybody. Happy Black August. For those of you that know and or don't know, this is the National Assembly of American Slavery Descendants and our media arm, the Black Civics Collective, where we do all things Black civics, trying to forward the movement for reparations, specifically for the descendants of persons enslaved in the United States, using humanitarian principles and giving people just basic education so that they know how to do more than just vote. That is not our primary directive, to get folks out to vote. However, we want young people in particular, those of you that are turning 18, those of you in your 20s that have not voted before. This is a pivotal election year, and it is important that now, between now and November 7th, you get educated not only about the candidates, but their platforms and the issues that they do support. So we want to welcome everybody to the show. I am Friday Jones, and today we do have a special guest lined up for you, Jasmyne Cannick. She is one of LA's favorite people, and she's going to be joining us very, very soon and very, very shortly. However, I wanted to talk just a little bit about Black August. Here we do have what is his name? Brother George. George, I think his last name is Jackson. Y'all forgive me. He looks a little like Q-Tip. But in any event, Black August really lifts up our Black liberation fighters. In our newsletter this month, for the month of August, for Black August, we talk a little bit about our imprisoned liberation fighters like Mumia, obviously Assata Shakur. We have Callie House, like the mother of reparations, who was brought up on charges by the federal government. These are liberation fighters fighting for freedom, fighting for justice in the United States. And Black August is a time that we remember and recognize them. And so as part of our culture, right, we have to take that time and remember those people. Black civics. Let's talk about what Black civics is. So Black civics, is how do you engage in the political process in these here United States, right? Whether you are voting, whether you are doing some work with the political party. We know that we have a two-party system. We have the Democrats, we have Republicans. We also have the Green Party, which has made some great strides. And we have Melina Abdullah and Cornel West, Dr. Cornel West. They both are doctors, Dr. Melina Abdullah and Dr. Cornel West, who are establishing the Justice for All Party. So whether you are working to do those kinds of things, lifting up candidates, whether you are part of a community group in LA, I know we have New Frontier Democratic Club. I am not familiar with a Black Republican club. So if there are LA people watching and there is a Black Republican club or a progressive Republican club, if that's such a thing locally, let me know. I will mention it. National Assembly of American Slavery Descendants. You join organizations that really are going to push justice causes and have you civically engaged with not only your municipal and local governments, but also your state government and your federal government. And then, of course, you can run for office. Some things, you can be appointed to, and you don't even necessarily have to run. I'm a commissioner for the city of Los Angeles's Reparations Advisory Commission. I was appointed by former Mayor Eric Garcetti. And so you can become civically engaged in different ways, but those are just some of the ways that you can become engaged. And that is the reason, again, that we do this show. And so the next thing I want to talk about, and we've been talking about it, and we have been getting some new numbers from different parts of the country, which is great. I was just in St. Paul, and I'll talk about that in a minute. But I do want to share, there it is. I do want to share our survey. So if you are able, please make sure that you scan the barcode. You can scan I'm saying barcode. It's the QR code, the little green circle with the square in the middle. Scan that with your phone, share it with your friends, share it with your family, church folks. If you are a Divine Nine, wherever Black people are, try to share this survey. We are really trying to focus on prioritizing needs in 2025 for reparations, because HR 40 has been in Congress, I believe, for 30, maybe 31 years. It has been in Congress since 1989, since I graduated high school. HR 40 has been in Congress, and it's time for us to really strategize on a plan B, not sit back and just wait and hope, that reparations happens. Even with all the advocacy that is happening around it, we need to absolutely make sure that folks are aware that there are policies that they can be fighting for actively. And if we can get the network of members that belong to NAASD, as well as our reparations, 2020, hold on, including our reparations 2025 coalition. Ooh, I'm sorry, you guys. Something is, the air is drying my throat out. Whew, this is why you need a co-host. In any event, Reparations 2025 coalition, which we've been working with different organizers from across the country that have been working to form a plan for whoever's elected in office the next 100 days, or the first 100 days after being placed into office, whatever presidential administration we wind up with. Reparations does not have the luxury of just having this person, this party. We don't have that luxury. It is a nonpartisan issue. And as such, we really, really do encourage you all. Again, let me show it one more time. We encourage you all to take this survey and share it with friends so that we can continue doing the work of prioritizing our reparations demands, and not only prioritizing the demands, but making the demands of legislators across the country so that we get the redress that we deserve. With that said, our guest is not in the studio as of yet, so I'm going to actually share our Zoom call for the Reparations 2025 Coalition. I'm going to stop my camera. I'm going to put this up on screen, and I am looking for the registration link because I do want to drop that. I want to drop that registration link into, I believe I can put it to go across the screen here as a banner, but I absolutely want you all to join in, and you can follow us on social media. You can follow us on social media. If you're following us on social media, the link is in our advertisements. It's the same link. We are down to our last two sessions. And this is session number 4. Session number 5 will be our last session, but we ask you to join us in this Reparations 2025 Zoom number 4. We've made great progress. We've gotten, as a coalition, our demands down. In addition to having our coalition demands down, what we will be focusing on our next session is drafting a letter and then having all of the people who have participated going out and getting 3 organizations to sign up on our letter. So this is really, really a very, very crucial this is a very, very crucial time for folks to go ahead and attend this meeting. The Zoom link is there. You can see it in our newsletter. You can see it in our social media. And if you go to our NAASD ORG on Facebook, Twitter, YouTube, now X, if you go there, you'll be able to see exactly how you can register for this. But again, this is our second to last session. Once we complete the second to last session, we will be going on monthly with the coalition meetings. And so this coalition meetings is very reminiscent of our old organizer meetings, where we are going to be reaching out as far as we can to organizations and to organizers, that really push Black issues. We're going to work very hardly to have we're going to work very hard to make sure that we continue this work so that our strategy is not just a right now strategy. We're going to continue to strategize from now until November 7th. And then after the president is elected, we're going to really have a first 100-day agenda and strategy. And so I encourage reparationists. I'm calling out publicly in NAACP. I'm going to call out Derek Johnson. I'm going to call out Mark Morial. I'm going to call out anyone who wrote into the OMB for disaggregation of data, whether you were for it or against it. This is a time for civil rights organizers and organizations, as well as reparationists, to come together for the betterment of Black folks. And so with that said, I'm going to share a short video, and we'll be right back after this short video.
Welcome. We are the National Assembly of American Slavery Descendants. Our mission is to advance the national movement for reparations. The United States Office of Management and Budget set 5 minimum standards for collecting racial data. The Black race is defined as a person having origin in any of the Black racial categories of Africa. NAASD has recommended that the OMB disaggregate data to accomplish 3 goals: decouple race from ethnicity, create an ethnic term that exclusively identifies descendants of persons enslaved in the United States, and create an ethnic term that preserves the American freedmen political status. The ethnogenesis of the African American identity is a result of ethnocide. The identity is from a people with shared history. Race, identity, plus ethnic identity equals peoplehood. Together, we can fix this dilemma with the OMB. We can build a coalition, grow the movement, and create a unified demand. What can you do to get involved? You can join NAASD today at www.naasd.org. You can email the OMB using our toolkit, or you can donate to NAASD so that we can continue this work. Thank you for your time. And stay connected with us on social media at NAASDORG. We are on Twitter, YouTube, Instagram, TikTok, Facebook, and LinkedIn. You can also sign up for our newsletter at www.naasd.org.
All right. And as many of you know, August 14th was a very important day for the Office of Management and Budget, as they are trying to decide what disaggregation of data looks like for descendants of persons enslaved in the United States. It's very important for us, even though the deadline has passed. We are not a monolith. That's a saying, right? We should put it on a t-shirt. We are not a monolith, and people identify as different things in this modern era. Because the government really did fail in providing an ethnic identification after the Civil War and during Reconstruction, where we really should have been ethnically identified as American freedmen, just like the Choctaw, Cherokee, Seminole freedmen, the 5 Confederate tribes. We should have had our own designation in the United States. However, this is a racist country, and we have lived under white supremacy. And as a result of that, we do not have that. One of the things that was said in March of 2024, when the OMB went ahead and released their decisions, and they decided at the time not to disaggregate the African American community, one of the things that they did recommend was that more research be done. And I actually as the president of NAASD, what we have discussed with our board is that there should actually be a stakeholder roundtable of Black organizations on this topic, particularly the ones that did respond to the OMB, whether they were for or against the disaggregation. But I think that stakeholder Congress, if you will, should be assembled, and we should advise the OMB, and they need to spend some money to do some research, but we can advise the OMB how to go into the areas of the country with the largest American freedmen populations, do some education on what it would mean in terms. Well, first of all, the average person, I don't think, even knows how the OMB collects data, what it's used for. But I think there needs to be education done, particularly in the Black Belt of the South here in California, which has the 5th largest Black population by state, to explain to people what it is that the OMB does and how disaggregation of data could be used to help identify some of the harms that are really specific to this community. And I think it should be done under, a Congress of Black organizations that not only advise the OMB on the research, but that are also paid, whether it's via, federal grants or consulting, however you want to say it, to actually physically go down and talk to our own people about this particular subject so that we can come to some sort of rational consensus. I think that's the next important step. And so that OMB piece is really, really important. We still do, unfortunately, not have Jasmyne Cannick in studio. And so you got to learn to be agile. We say it all the time. You have to be politically agile. Being politically agile means not just voting for the same party. This is not football. Sometimes you have to vote for your party because you are rewarding them. Sometimes you have to not vote for your party because you are penalizing them. That includes changing parties when necessary. That includes getting behind third-party candidates. That means breaking the paradigm that has already been built to be structurally biased in how it was made up. Racism is so baked into America. Things that we think are normal, we are afraid to deviate from. But for us as a people, we have to be politically agile. And you're going to see me be agile in real time, because what we are going to do in the absence of Jasmyne Cannick, if she comes through, we will be agile again, and we will bring her on in here. But what we're going to do in the interim is read the complaint from Evanston. I don't think we've done that one before. I think we did Fearsome Fun, and I think we did Tulsa. I don't think we did the complaint for Evanston. And I had the honor and privilege of meeting Dino, and I forget Dino's last name, but he is such a powerhouse in Chicago and in Evanston, Illinois. And it was his research that was used in order to do the work that the Evanston Commission did. And I had the privilege of being on a panel with him at the National Black Journalists Convention Association, but at their convention in Chicago about 2 weeks ago. And I enjoyed speaking with him. I enjoyed the fact that he said Evanston did what they thought was the best at the time. And I told him I had been a critic. I told him I had written, some of my challenges with Evanston in its formation. They have moved from benefiting 16 families to, I think he said 80 or 88 families out of the 450 families that qualify. So they're still not at a point where everyone has been made whole. However, they're moving closer to that goal. There was an underestimation of the cannabis taxes that were going to be used for the fund that was going to do these 25,000 home repair grants. And because of that, they had to go back to the drawing board. They had to find more money. And even though I have been critical of Evanston as a commissioner, I've also learned from Evanston. And so I did appreciate his humility in saying it was a starting point. There was a journalist also on that panel, and I will find the article and I will share it on social media. He went back and he did a deep dive article, an investigative report on Rosewood. We know that Rosewood, and I have to stand corrected because I always said, well, Evanston is the second municipal action. Technically, Evanston is the first municipal action because Rosewood was done through legislation at Florida's state level in the 1990s, and it had conservatives that voted for lineage-based reparations through Rosewood. And what the journalist did is he went through, I think he found a family that had 3 generations that had gotten that education through that particular piece of legislation, that particular piece of reparations, and he really did a deep dive into Rosewood. And so I want to respect the fact that Rosewood, not California, Florida, Rosewood was the first state action, and California is the second state action. However, the scale at which California is moving forward is a significantly larger scale. So with all of that said, let's take a quick deep dive into Evanston. And I'm going to share my screen. We're going to do this. Okay. And so you guys, we're going to do a read along, and we're going to get to this. This is in the United States District Court for the Northern District of Illinois, the Eastern Division. We have Margot Flynn, Carol Johnson, Stacey's Neimanis, Barbara Regard, Henry Regard, and Steven Whalen as the plaintiffs against the city of Evanston. And we're going to continue to watch this, but I want us to understand, and this is a short complaint. It's 9 pages long. We got about 24 minutes. We're going to really try and power through this. So plaintiffs Margot Flint, Carol Johnson, Neiman's, all the people that I just named, bring this it's a class action lawsuit challenging on equal protection grounds. So they're using the U.S. Constitution, defendant city of Evanston's use of race as an eligibility requirement for a program that makes $25,000 payments to residents and direct descendants of residents of the city 5+ decades, if not more than a century ago. Plaintiffs seek a judgment declaring defendants' use of race to be unconstitutional. Plaintiffs also seek an injunction enjoining defendant from continuing to use race as a requirement for receiving payment under the program, and request that the court award them and all class members damages in the amount of $25,000 each. This is interesting because they didn't just leave it about the race part. They actually included the descendants of residents, and I feel like that distinction is 2 different classes. And so I'm curious to see how the judge is going to rule, if the judge is going to make 2 distinct classes, or if they're going to just lump it all in one. If we remember from the Tulsa case, honestly, that judge, she just used a bunch of word salad and was like, this is what we're doing today. So this will be a good one to watch. Anyway, jurisdiction and venue. The court has jurisdiction of this lawsuit under 28 USC, and it gives the regulation 1331. Venue is proper under 28 USC, and it gives us regulation 1391. The parties. Plaintiffs, Margot Flynn is at least 18 years old of age and is a direct descendant of Evanston residents. Plaintiff Flynn's parents and grandparents lived in Evanston between 1919 and 1969 and were at least 18 years of age at the time. Plaintiff Flynn does not identify as Black or African American, nor did her Evanston parents or grandparents identify as Black or African American. Plaintiff Johnson is at least 18 years of age and is a direct descendant of residents. So now they're using their lineage against us. Do y'all see what's going on? They are using their lineage against us. So now Neiman's basically says the same thing between 1919 and 1916. They are descendants of residents. Wow. Okay. Reparationists, pay attention. So all 4 and 5, 6, however many of them are saying the same thing. Factual background. Through a series of resolutions adopted by Evanston City Council, Evanston created a program to provide $25,000 in cash payments to residents who lived in Evanston between 1919 and 1969 and their children, grandchildren, and great-grandchildren. The program, entitled City of Evanston Local Reparations Restorative Housing Program, uses race as a requirement for receiving payment and purports to remedy housing discrimination experienced by Black and African American residents. It's interesting that that's distinct 55 to 105 years ago. The city committed at an initial $10 million to the program. At the time it was created, it committed an additional $10 million of November 2022. Following an initial set of applications, further applications will be accepted on a rolling basis. At no point has Evanston asserted that the program is closed. Well, so that means that the program is still open. As part of the application process, applicants are required to state whether they and their ancestors identify as Black or African American. Interesting. I wonder if they asked the question if they were descendants, but I know they must have at some point. The first group of persons eligible for $25,000 payments under the program are current Evanston residents who identify as Black or African American and are at least 18 years of age between 1919 and 1969. Evanston refers to this first group as ancestors. To date, the city has approved payments to 141 ancestors, and at least 129 already received payments. Okay, the second group of persons eligible, so this gets down to the classes, the classifications. The second group of persons eligible for $25,000 payments under the program are individuals who identify as Black or African American, are at least 18 years of age, and have at least one parent, grandparent, or great-grandparent who identifies or identified as Black or African American, lived in Evanston between 1919 and 1916, and was at least 18 years of age at the time. Evanston referred to this second group as direct descendants. We're going to have to actually pull out the Evanston bill and actually read that bill. A direct descendant is not required to be a current Evanston resident to receive a payment. That's great because that means it follows them where they go, as it should. At no point in the application process are persons in the first and second groups required to present evidence that they or their ancestors experienced housing discrimination or otherwise suffered harm because of an unlawful Evanston ordinance, policy, or procedure, or some other unlawful act or series of acts by Evanston between 1919 and 1969. In effect, Evanston is using race as a proxy for having experienced discrimination during this time period. This is going to be interesting to watch because covenants are a thing. And it's interesting, being in St. Paul, Minnesota, and Minneapolis, there's something called something mapping, and it has to do with mapping out all of the different blocks and houses that had those racist covenant clauses on them. And there's a university, I think it might be the University of St. Paul, don't quote me, but I think it's the University of St. Paul, that is actually, the students are removing the language from the deeds. And I think it's important to remove the language from the deeds. However, I also think it's important. We have a way of erasing our history in a way where it's just gone. And I think it's important on some of these blocks that those blocks, just like if you go to a historic site, they usually have those steel markers that, stand and tower over you. And, it'll say on this date, such and such event happened here, or this was the home of so and so, the president, the vice president, whatever. We got all these little markers across the country. I think it's important when we do work like this to actually put markers on the blocks that did have covenants. We have to constantly in this country, just like they did in Germany, put markers so people don't ever forget. So the racists don't go back to being racist and think it's okay to have covenants in properties in the first place. This is going to be interesting to watch. Okay, a third group of persons eligible for 25,000 payments under the program are current residents of Evanston who are at least 18 years of age and can show that they actually experience housing discrimination after 1969 because of an Evanston ordinance, policy, or procedure. Unlike the first and second group of recipients, Evanston does not expressly use race as an eligibility requirement for the third group. Well, that's because it was illegal after 1969. But anyway, on March 27, 2023, Evanston expanded the program to include an option to receive a direct cash payments. Good. We know that was one of the primary gripes that I actually had with it when I did my write-up a couple of years ago, was that it wasn't direct cash payments. So I'm glad to see that they have made progress, just like Dino said. As of October 5th, 2023, Evanston was still verifying direct descendant applications, including applicant, quote, ancestor information. So they are doing their auditing. Good for them. By January 11, 2024, Evanston had approved 454 direct descendant applications, but had not made any payments on the approved applicants. The city has represented that all 454 will receive $25,000. On or about January 11, 2024, Evanston randomly assigned selection numbers to the 454 approved direct descendants. I don't know why they didn't just take them first come, first serve. That's weird. But to determine the order in which the payments will be made. Evanston anticipates making 25,000 payments to at least 80 approved direct descendants in 2024. The remaining approved direct descendants presumably will be paid sometime after 2024. As of, and I got to do a time check. Okay, we got time. As of May 1st, 2024, the city had met with 70 of the 80 direct descendants who are most likely to receive payments in 2024. Some 60 of these direct descendants opted to receive a direct cash payment. Good for them. Yes, for the cash payments. At all relevant times, plaintiffs satisfied and continue to satisfy all eligibility requirements for participating in the city's program as direct descendants other than the race requirement. At all relevant times, plaintiffs were able and ready to apply for payments under the program and would have applied, but for the program's race-based eligibility requirement. Plaintiffs remain able and ready to apply for payments under the program and intent to apply if the race-based eligibility requirement is declared unconstitutional and enjoined. So their only thing is race. I could understand if they put in here, my ancestor was a woman, because we know women didn't have rights. But then why wouldn't you just go and take this as a model and then write it for women, descendants of women who were discriminated against? Why wouldn't you take your classification of discrimination and take this as a model and say, we're going to do the same model? Why do white people, dear white people, my Irish cousins, my French cousins, I'm talking to y'all, even though I don't present as white, we have done the ancestry. And so, my dear cousins, why is it that y'all do this? Why don't you all go and actually learn something from the Negroes, learn something from the Black people, and then do your own whatever to make it happen for yourselves? Why are you all the crabs in the barrel? People want to talk about Black people, crabs in the barrel. I don't know what they're talking about. Why don't you all stop acting like the crabs in a barrel and actually self-advocate and get something for yourself if you were discriminated against? I don't understand this. Anyway, continuing on. But for the program's race-based eligibility requirements, plaintiffs would be in line to receive $25,000 direct cash payments as direct descendants. They don't say that they were harmed in any way. And we are on now, let me see, we are on this thing is only 9 pages. We are at page 6. So we're going to keep on going. Plaintiffs bring this class action under Rule 23 of the Federal Rules of Civil Procedure. The class includes all individuals who are able and ready to apply for the program and are eligible for a $25,000 payment, but for the program's race-based eligibility requirement. The class is so numerous that joinder of all members is impractical, as plaintiffs estimate that if given the 50-year time period covered by the program and the city's population during the period, the number of members is in the tens of thousands, if not more. This reads as hateration. There are questions of fact and law common to all class members, as class member is eligible for $25,000 payment, but the program's race-based eligibility requirement, which violates the Equal Protections Clause of the 14th Amendment to the U.S. Constitution. Plaintiffs' claims are typical of other class members, as Evanston is discriminating against each member on the basis of the member's race in violation of Equal Protections Clause to the U.S. Constitution. I'm going to take a pause right here before we get into paragraph 29. Bear with me, people. Bear with me. I know we don't need a commission. We don't need a commission because by any metric, pick a metric, we are at the bottom of this America caste system. We are at the bottom of this society. You name it: homelessness, life expectancy, birth mortality. We live by the cancer alleys, right? We got all these EPA issues. We live by the cancer alleys. You name it, air quality, anything that you could think of, our employment within the actual military, and how many Black generals do we have? How many Black American freedmen presidents have we had? We can look at any metric, right? We can look at any metric and go, we're at the bottom. That clause right there, that 28 plaintiffs' claims are typical of all other class members, as Evanston is discriminating against each member on the basis of the member's race. The reason that we have commissions is so that we can say, Evanston did this, Evanston did that, it cost these people this much in generational wealth, and as a result of all the actions that Evanston did against these people, this is the remedy for it. And I hope that Dino, who I did meet again in Chicago, I sincerely hope that what was presented in Evanston backs that up in a way that makes this defendable. Because if it does not, this is going to be a train wreck. And this is going to, just like the Fearless Fund, is going to be a problem for the reparations movement. Going on to 29. Plaintiffs fairly and adequately represent the interests of the other state members, as each class member is eligible for a $25,000 payment if Evanston's race-based eligibility requirement is declared unlawful and enjoined. A class action can be maintained because prosecuting separate actions by individual class members would create a risk of inconsistent or varying adjudication with respect to individual class members that would establish incompatible standards of conduct for Evanston. Prosecuting separate actions by individual class members also would create a risk of adjudication with respect to individual class members that, as a practical matter, would be dispositive of the intentions or interests of the other members, not parties to the. Basically, they're saying we got to do this as a class action, because if we do it individually, we could get a mixed bag of nuts. A class action can be maintained because Evanston has acted on grounds that all apply generally to the class, so that the relief sought is appropriate for the class as a whole. A class action can be maintained because of the questions of law of fact common to class members predominate over any questions affecting only individual members. As class action is superior to other available methods for fairly and efficiently adjudicating the controversy, because all class members are subjected to the same equal protections violations, and but for Evanston's racial discrimination, all class members would be eligible for $25,000. This makes me wonder. So let's just say these people win this case. They get their $25,000. Does this mean that the tens of thousands of people that they say the city can't afford to pay the $25,000 to can come now and collect their $25,000? Does it mean that these people are willing to bankrupt their own city just to stop the descendants of Black folks who were subject to racial discrimination, block covenants, not receiving loans and funding? Does it mean that it was worth all of that to these 5 or 6 people? I really have to add, again, my white cousins, I'm talking to y'all because I'm trying to make it make sense. I'm trying to understand how people who have ancestry in America, as long as Black folks have ancestry in America, are fighting against reparations. Make it make sense. Back in the day, the white people used to get on a bus to do voter registration in Mississippi. What are y'all white people doing today? Moving on to 33. Plaintiffs re-allege paragraphs 1 through 32 is fully stated herein. Defendants' use of race as an eligibility requirement for payment is an express policy or widespread practice to so permanent and well settled that it constitutes a custom or practice for purpose of municipal liability under Monell. We might have to pull this case up. Monell versus Department of Social Services. I think that's what all those abbreviations are supposed to stand for. Plaintiffs enjoy the right to equal protections as the laws are protected by the Equal Protection Clause of the 14th Amendment to the United States Constitution. Defendant acting under color of law. If you haven't read that book, you should read that book. That's, I think, Rothstein's book, where he even talks to some of this stuff. But anyway, defendant acting under color of law is depriving the plaintiffs of their right to equal protection by purposefully and intentionally discriminating against plaintiffs on the basis of race. Defendants' use of race as eligibility requirements injure plaintiffs because it's a barrier that prevents plaintiffs from participating in obtaining payments under the program's footing with persons who are able to satisfy defendants' race requirements. Plaintiffs also have injured the defendants' use of race as an eligibility requirement because, but for the requirement, plaintiffs basically would be eligible. This is what I hope the attorneys are doing for all of these people that claim that they are being injured today. I sincerely hope that these attorneys are digging through the deeds, the wills, the trusts of these people to see whether or not they lived inside of homes with restrictive covenants. And if they lived inside of homes with restrictive covenants, it means that these are white people. And if they were able, through a will, through probate, through trust, to actually have an estate that they could give to the next generation, whether it's their children, grandchildren, niece, nephew, whoever, if they have an estate that they were able to pass on to the next generation, there is something in the tax code called a bump up, a tax bump at the time of death. That means your parents bought this house, they lived in it for 30, 40, 50 years, they died. The value, the fair market increase from the day they bought it to the day they sold it becomes the new basis, tax basis, when they pass it on to you. So let's just say these people bought houses for $10,000. They died in 1960, and the house, instead of being worth $10,000, became worth $100,000 or $50,000, any number, right? That $50,000 now is wealth that the kids did not generate on their own, that the grandkids did not generate on their own. But if they were handed that house as an asset, or if it was sold through probate court for that cost, that new valuation is the wealth that was generated. So the difference between the 10 and the 50 is $40,000 of wealth creation that was then given to the next generation. In addition to that, these attorneys need to go ahead and look at whether or not any of those people were able to take out second mortgages for their kids to get an education, because what they would be qualifying at that point in time is not only the step up transfer of wealth, they would be able to do a step up to, they would be able to quantify the additional wealth that was extracted during the term of ownership. And if they run those parallels to the people who were called descendants to see what happened to the same people who couldn't live in certain areas, who were relegated to Black areas, whose homes had lower value, now we got a conversation going. I would love for them to do that as a strategy. And I'm an accountant. I am not an attorney, but if I was on the team and I had to give them a strategy, that would be some of the stuff I would be recommending that they dig up, because this isn't just about race in a modern context. It's about wealth loss over that period of time, that 1919 to the 1969, over that 50-year period of time. And so we can't ignore that. So I'm glad we only have a couple of more pages, but we almost don't even have to read anymore. We get the gist of why the people are suing. We are going to continue to watch this, and we are going to continue doing these. Let me stop sharing this. We're going to continue doing these pop-up reads of these cases, and I have some other cases that we're going to continue to do because it's really important to our work. I don't understand, again, if these white people had claimed, and they're not claiming it, right? We just read what they are claiming. None of them said that their ancestors were denied anything. What they're saying is, in a modern context, we're being denied. So we don't care about your repair. We don't care about your harms. We don't care about the fact that you had to live next to the factories, that were putting toxins in the air or lead in the air or whatever. We don't care about the past harms. We want to look forward and keep moving. And so that is a whole problem. I am sorry that Jasmyne Cannick was not here, but I'm glad that she wasn't, because we were able to delve into this case. Hopefully we can bring her back at a time in the future. Before I go, though, I do want to share some wonderful, wonderful California news. You guys know we've been all over the internet. And so Senator Bradford and his 3 bills have gone through Appropriations Committee. It has passed appropriations, and so it's going on to the next step for us. For the people who are suing in Evanston, you have absolutely no idea what it takes for descendants of persons enslaved in the United States to get the United States government, or any body of government, including Evanston's body of government, to be working for us. And the effort it takes to get these laws on the books, to get them voted on, to get them passed, is like a monumental feat. And when you come with a petty, such a petty case like you are with Evanston, it really just diminishes the value of the work that it takes for us as a people to have our government work for us. Your government works for you every day. And I'm so proud. I got to shout out, CJEC, Camila Moore, the AB 3121 task force, and all of the people who wrote in. I saw that there were 7,000 letters that were written in for this specific piece, the appropriations. And so in California, SB 1403 will create a state agency, basically a Freedmen's Bureau to house all the reparation that needs to be done. SB 1331 creates a state fund, and that is necessary. We saw in the papers it was $12 million that's being allocated in order to create this fund. And then SB 1050, I got to shout out Kavon Ward and Where Is My Land, because they worked on that bill with Senator Bradford to continue, just like Bruce's Beach, the restitution for land taken. And so for everyone, that called in, wrote in, tweeted, got social media involved, who did the media that actually covered it. One of the things I talked about at the National Black Journalists Association conference was it's necessary for these stories to not just be regional, because if someone in Atlanta, a newsroom picks up like the winds in California, if someone in Texas is picking up what's happening with the commission in New York, if someone in Ohio is picking up what's happening in Detroit and St. Paul, now across the country, the different municipalities are seeing what each other is doing. And it's important for there to be that kind of visibility. And it's important for our broadcasters, Black, white, Latino, Asian, other, to actually advocate for these stories. It's very important that you advocate for these stories, because we are in a time where we are actually making history, and we can't forget that. We cannot forget that. I want to share a quick little collage. This is some pictures. Down on the bottom right is some history on the Dred Scott family. Seeing where they lived in the fort, in a room. The room is probably half the size, not even. The room is probably about a third of the size of my living room. And there were no beds. They probably slept on pallets. Harriet and Dred Scott, he and his wife and 2 girls. The timing that they decided to fight for their freedom was as their girls were coming of age. I do not take that lightly. While he was fighting for his freedom and his family's freedom, he had to live in jail. They would not even allow him to be free. So when we wonder where that bond system comes from, and no, we rather you sit in jail while you wait until you have your trial, it goes all the way back to Dred Scott. And this is a fort, the Fort Snell, I think it's called, is a United States Army fort. And so the U.S. Army is complicit in slavery in the United States. We also had a chef down on the bottom left, who she actually cooked live in front of us and did a presentation on soul food, which was very, very important. And then in the middle, this is Earn the Black Vote, which talked about, how reparations is good for America. And we definitely believe that reparations is good for America. And so I just wanted to share that little clip. Reparations is taken off. And as I continue traveling and speaking around the country, the one thing that I'm seeing is people understand the descendant message. There was a brother there, he senior, an elder. He was 90 years old and he was sharp as a tack, y'all. And he basically said, I identify as a descendant. And that was powerful. That was awesome for me to see. And so as we wrap up, I just want you all to know we will be back with another episode of Black Civics on September 1st, which is the holiday weekend, but we're going to do it anyway. So make sure you stay tuned. Make sure that you like and share the video. Make sure you tune in and click the bell. We're building the YouTube channel, so make sure you follow us on YouTube, subscribe and click the bell, because we are going to continue to do pop-ups. We've got about 5 or 6 cases that we think it's important for folks to be familiar with in the reparations community, because they're going to matter long term as we continue to articulate our demand, particularly around disaggregation, self-identification, having a protected status in these here United States. Again, take our survey, follow us on social media, be engaged. Peace and reparations, and happy Sunday. Thank you so much for tuning in.